Salam and welcome to SomaliDispatch.com's YouTube channel. My name is Abdulqadir Guleid. Somaliland's Supreme Court today ruled on the dispute revolving around the Bill/Law 14, which has to do with the registration of new political associations versus the presidential elections. We discuss the court's decision with Guleid Jama, a lawyer world first in the ongoing dispute. He joined us from Hargeisa, Somaliland. Salam and welcome, Guleid Jama, and thank you for joining us. I understand it's a bit late on your time, but given the situation, we appreciate you joining us. If you can start us off by giving us a brief on the court ruling today and how we got to where we are, and how is it that the interpretation or the clarification needed got to the Supreme Court of Somaliland would be great.
Thank you very much. And this has a bit of a long history, which I don't want to confuse the public. But the law in question relates to how new political parties should be registered in Somaliland. And this started way back when the constitution was approved in 2001, because that was the first time post 1991 Somaliland, and new parties should be formed. There was no precedence in that aspect. Then this law came into force, which covers registering new associations, new parties, and then governing those who get approved to become a permanent parties. Basically, the law says, after some amendment, is that every 10 years, new political parties can be registered or should be registered, and elections should be held. Those who get the highest numbers in all the districts and regions of Somalia will become the permanent members, permanent political parties in the coming 10 years. The license of the current political parties expires December this year. What has happened then is, because of delays of elections, particularly local elections, there has been disruptions on the way the law used to cover how political parties should be competed, because it was about the local councils. Within the local councils, new political associations, parties will run to compete. Those who got the highest numbers will become a permanent parties. But that has been delayed over times. Therefore, there is no local elections in this year, and the license expires. What is the solution? The House of Representatives approved a bill, amendment to the bill. It went all the way to the president. The president vetoed it. We have a similar system like that of the US, where the president can retain a law. But what happened is, the president didn't return the law or the amendment within 21 days, which is the specific date he should do. His argument was that there was a transition due to the elections, May elections. But others argued that because of the expiry of the 21 days, the law should be applicable automatically. That's where the differences started. Then 47 members of the parliament submitted a case asking the Constitutional Court to interpret a particular article in the Constitution, saying the president should retain amendment submitted to, or bill submitted to him within 21 days, or should sign it. If he doesn't do that, the law will become automatic. That's one case brought to the court by 47 members. Bear in me, because it's a bit complicated. Another case was submitted by 24 individuals, most of them politicians. They were arguing that despite these amendments, the existing applicable law allows them to open new political parties in this year, May this year. Therefore, no matter what that amendment is, we don't care about that amendment. The current law allows it. Therefore, the court should decree that these individuals and anyone else in Somaliland have the constitutional right to register new political parties. The court today issued two separate decisions. It said the case submitted by the members of the parliament is inadmissible due to procedural grounds. They said the way they submitted is not in accordance with the laws, with the procedures. Therefore, it closed that case. It didn't decide on the merit or the substance, but it said procedurally it's not admissible. The second case, submitted by the members of the public, 24 individuals, most of them politicians, aspiring for new parties, the government ruled it in favor of them. And they said, and the court said, it's not the government, I mean the court. And the court said, new political parties should be registered in this year. And that the competition of the political associations and parties should happen without need of local councils. Therefore, the association parties will compete separately. Therefore, you will be voting for X party or X association, and those who get the highest numbers will become the members of the permanent parties in the coming 10 years. That's what the court said. And I'm sorry if I complicated, already very complicated thing.
No, that was eloquent, and thank you. Your reaction in a brief reply to those 6-point decisions.
I think what I'm hearing so far is about all parties welcoming the decision. I'm not sure if some of them has misinterpreted it, or therefore in the coming days we may be hearing, or we might hear something different. But so far they all agreed, and that's a good news. As you know, there was a heated debate, very heated political debate in Somaliland. Therefore, at least this cools down things at some point. And secondly, political associations will be registered in this year, and I think that is good for people who wanted to have a political parties. But I think it's not the end of the history, because after a couple of weeks and a couple of months, there will be a debate and discussion about dialogue. I think preferably about which election should happen first. Should we hold the presidential election first, or should we hold the associations parties election first? And that's where the position and the ruling party differ drastically.
Right. There is the school of thought or the understanding of the 6-point ruling has within it an overstepped perhaps role or a mandate by the Supreme Court, which adds to the bill or the law 14, which kind of, is not their role. Your reaction to that?
I think what the court has done here is it's the original act, number 14, is still applicable. There was no dispute about that. It subtracted some articles, removed some articles, particularly the articles that were ordaining that parties can compete only in local councils. It said that's no longer needed. And it included a new article or new inclusion, which says they will run automatically, like parties and associations. That looks like, for many lawyers, including me, as a lawmaking role. It doesn't look like a judiciary function. It looks like a function of amending a law. The court has a power to say certain provisions are unconstitutional. That's fine. It hasn't said that, but it said these articles are no longer needed. I remove it from the bill, from the act, and I include in this law. I think that will remain debatable in a very long period of time in Somaliland, because according to the Constitution of Somaliland, roles are very separate. The lawmaking, it vests solely with the parliament. It can't move to the judiciary.
So can the court overrule that? In other words, there cannot be a law or a ruling that violates the constitution of the country. And since their decision or decree kind of oversteps that, what's the remedy? And I know there's no precedent for this to discuss or to, and perhaps this would be the basis for all that don't agree with this would basically hang their coats on. Isn't that a bit of where maybe perhaps the House of Representatives will step in?
The decision of the Constitutional Court is final. Therefore, I don't think there is any way it can be overruled. From now on is the law of the land. It should be implemented as it said. I think the debate and examination of the court ruling should inform future decisions, but this decision has been taken, and as a final constitutional court, the parliament doesn't have the power to overrule it. It can go to enact new legislation, for instance, a legislation that administers the constitutional rules, the rules of the Constitutional Court, which is absent. We don't have a law that addresses how the Constitutional Court should handle the matters, and that vacuum, legal lacuna, may have contributed to the decision of the court. Therefore, that can be done and methods can be taken, but I don't think there's a legal way to overrule the decision of the court.
Okay. This push for registration of new parties stems from the so-called disappointment with the current three national parties, coupled with the president's alleged interest in an extension in his term. Would you agree with some of that sentiment?
I think it is an opinion, like it's a matter of, it's a subjective discussion. You know, people will have a different opinion on that. And I don't want to impose any of my opinion on a legal matter. Therefore, there are people who think that political parties are not working properly, and therefore there should be new political associations. There are those who think the president is orchestrating the entire process to get an extension. These are allegations here and there. What is important here, what is legal, is that the current law and the amendment agree that in every 10 years, new political parties should be registered, and the 10-year expires in this year. Therefore, that's end of history. The discussion could be how that could be done, and I think that's what ended up before the court now, and the court has made a ruling. Therefore, I think the way forward is to how to enforce that and make sure the way ahead is less thorny.
Right, and if in my understanding, and correct me if I'm wrong, the three political parties are also fine with their tenure, but the push to start registering political parties right now was the crux of the dispute. Finally, whose court is in the poll right now? Where do we go from here?
When it comes to the decision of the court, it is then the relevant authorities, namely the registration commission, the commission that's responsible of registering new political parties, then should start the process. They should put in place guidelines and procedures, consult with the public, and make these guidelines and procedures public. And afterwards, they start accepting applications from those who are willing to form parties, and that will start roughly on April, May this year, as the law says, and in June this year, the commission should release those associations that are eligible to run in the elections, and then that moves to the election commission. The election commission will start from there.
Thank you, Guleid, for explaining the decision and what's at stake. Thank you for joining us tonight.
Thank you very much. Thank you for having me.